Rural America, watch out. The Democrats here in Washington are pushing for legislation this week that would be the biggest bureaucratic power grab in a generation and directed right at Americans' heartland. A little talked about bill with huge implications will be considered this Thursday before the Senate Environment and Public Works Committee. The bill, named the Clean Water Restoration Act, is sponsored by Senator Feingold of Wisconsin. It seeks to require a federal permit for just about any activity that could affect virtually any body of water. In other words, the bill would extend the scope and the reach of federal water jurisdiction beyond anything that ever existed under the Clean Water Act.
The committee will now first consider the Clean Water Restoration Act. The committee has an agreement cleared on both sides that if the Baucus-Klobuchar-Boxer amendment is approved, the text of S. 787 as amended by the Baucus-Klobuchar-Boxer amendment will be the base text for the purposes of further amendment. The text was circulated yesterday morning.
My amendment restores the jurisdiction of the Clean Water Act to what it was in 2001. No more, no less. So, Madam President, I call up the Baucus-Klobuchar-Boxer Amendment number 1 and ask for its consideration.
I would like to request that both the majority and the minority counsel come to the desk and respond to questions. Would that be reasonable?
Very reasonable.
All right. The proposed amendment says that the objective is to return federal jurisdiction to where it was January 8th of 01, which is prior to the first of the two decisions. That was the Swank decision. Does this mean federal jurisdiction would extend to any wet surface upon which migratory bird could land, as the Corps of Engineers and the EPA believed on January 8th of 01?
No, Senator, it does not mean that. Senator, I beg to differ with learned counsel because what the bill says is that the legislative authority would be what Congress under the Constitution could do, and then specifically references the decisions that both EPA and the Corps of Engineers made prior to January 8th. And prior to January 8th, 2001, the Corps of Engineers had promulgated the migratory waterfowl rule, which said that migratory waterfowl landing on a body of water made that body of water subject to federal jurisdiction. That was specifically the holding in the Supreme Court overturned in its decision in Swank.
All those in favor of the Baucus-Klobuchar-Boxer amendment say aye. Aye. All those opposed say no.
No.
The opinion of the chair, the ayes have it, and the amendment is agreed to.
I want to take less than a minute to get some brief words in why I think that rushing down this road is a bad idea. It's a vast expansion of the jurisdiction of the Corps of Engineers and the EPA. It would remove the limitation navigable in the Clean Water Act and replace it with waters of the United States. This seemingly minor change would give the federal government the power to regulate everything liquid, from farm ponds to stormwater retention bases to roadside ditches, desert washes, streets and gutters, even to a puddle of rainwater.
This bill is a radical change of present law for several reasons, and the biggest of which is we're removing the word navigable from the law. We're moving from navigable waters of the United States to all waters of the United States. That's a huge expansion of federal authority, and the last amendment doesn't change that fundamental expansion. In terms of the fundamental issue of expansion under this bill, if there's no attempt to do that, can we simply by voice vote amend the bill to not take the word navigable out of present law?
No,
that seems to be a major change from present statute.
Well, you misunderstand what we're doing.
Basic common sense absolutely tells you that to change the statute from navigable waters of the United States to waters of the United States is a major change and a dramatic expansion. That's fundamental common sense, because we would be changing statutory language from navigable waters to all waters.
You've indicated that there's a desire here to go back to the state of the law before the two Supreme Court cases. And I can, if you look at the status of the law before the two Supreme Court cases, there had been an extremely expansive interpretation of the term navigable waters by the agencies. There was a belief, which the Supreme Court upheld, that the interpretation of the term navigable waters had been expanded far beyond its legislative intent and its meaning. And that's what the Supreme Court did. The Supreme Court pulled that unjustified expansion of the term navigable waters back into a proper realm. If the effort is to go back to the status of the law before those two cases, are we going back to the law which referred to navigable waters? Or are we going back to the interpretation of that term by the agencies, which expanded it far beyond any reasonable definition of that term? That's the debate we are having here.
Thank you very much, Madam Chairman. I call up Barrasso Amendment number 1. Madam Chairman, this amendment prevents language in this bill that would federalize all streams and intermittent streams from the 50 states. And I have a picture here showing how this is. My home state of Wyoming regulates the streams, including the intermittent streams within our state. We have a state law. It is called the Wyoming Environmental Quality Act. In it, the law states waters of the state means all surface and groundwater, including waters associated with wetlands within Wyoming. Nowhere does this give authority to Washington.
This is a different Republican Party than the Republican Party of the past. Richard Nixon is the one who got this law on the books, the Clean Water Act. Ronald Reagan carried it through, and I assume that those of us who voted for it will vote against this exemption. It would take this whole effort way back. It would take us back to the 60s, well, back to the far past. So all those in favor of this amendment, please say aye. Aye. All those opposed say no. No.
I would like to call amendment number 6, which is the amendment which prevents the Clean Water Restoration Act from having the Environmental Protection Agency take control of all prairie potholes.
All in favor, please say aye.
Aye. Aye.
All opposed, please say no. No.
No.
Opinion Chair, the noes have it. Amendment is not agreed to.
I'd like to call up Barrasso Amendment number 7. This amendment prevents the Clean Water Restoration Act from having the EPA take control of all wet meadows.
All in favor, please say aye.
Aye. Aye.
All opposed, please say no. No.
No.
Opinion Chair, the noes have it. Amendment is not agreed to.
This amendment prevents the Clean Water Restoration Act from having the EPA take control of all natural ponds.
All in favor, please say aye.
Aye. Aye.
All opposed, please say no. No.
No.
Opinion Chair, the noes have it. Amendment is not agreed to.
And this amendment would exempt agriculture.
All in favor, please say aye.
Aye. Aye.
All opposed, please say no. No.
No.
Opinion Chair, the noes have it. Amendment is not agreed to.
This amendment prevents anything in the bill from requiring federal EPA permits as a result of this act for livestock production.
All in favor, please say aye.
Aye. Aye.
All opposed, please say no. No.
No.
Opinion Chair, the noes have it. Amendment is not agreed to.
I'd like to call Barrasso Amendment number 12.
Go right ahead.
The Clean Water Restoration Act, Madam Chairman, says it is in the findings. In the findings, it says that groundwaters are treated separately from waters of the United States for purpose of the Federal Water Pollution Control Act.
That's what we want.
And are not considered waters of the United States under this act.
Good.
Well, Madam Chairman, it's my understanding that findings do not have the force of law. So this amendment just gives our small and large businesses the assurances that they need by excluding groundwater in the actual text of the bill instead of the findings.
All in favor, please say aye.
Aye. Aye.
All opposed, please say no. No.
No.
Opinion Chair, the noes have it. Amendment is not agreed to. If there are no additional amendments, I move S 787 as amended be reported favorably to the Senate. Is there a second? All those in favor say aye. Aye. All those opposed say no.
No.
Opinion Chair, the ayes have it. The ayes do have it. Given this vote, the bill is reported favorably to the Senate.